Generally, federal antitrust laws, including the Sherman Act, prohibit anti-competitive behavior only when the behavior occurs in interstate trade or commerce. As a result, parties who supply goods to retailers in different states or manufacture goods in one state and sell those goods to businesses in another state can be liable for antitrust violations. But what about professional baseball? Is hosting baseball games an activity involving interstate commerce that falls within federal antitrust laws? The United States Supreme Court considered this question in the case of Federal Baseball Club of Baltimore versus National League of Professional Baseball Clubs. In the early 20th century, there were two major professional baseball leagues in the U.S., the National League and the American League. The National League and the American League signed the national agreement under which they united to form a joint venture known as the National Association of Professional Leagues, otherwise known as Minor League Baseball. The association functioned as a training ground from which major league teams drew new players. In 1913, a third league, known as the Federal League, formed with 8 teams, including the Federal Baseball Club of Baltimore, which we'll call Baltimore. 2 years later, the Federal League, the National League, and the American League signed a peace agreement under which the Federal League dissolved and all of its member teams, but Baltimore, accepted buyout offers from the remaining teams. Subsequently, Baltimore sued both the National League and American League in D.C. Supreme Court for violating the Sherman Act. Specifically, Baltimore argued that by signing the national agreement, the National and American Leagues conspired to monopolize baseball because the agreement gave the two leagues control over practically all players capable of playing at the major league level. Consequently, Baltimore asserted the Federal League couldn't compete and was forced to dissolve, causing its member teams, including Baltimore, to suffer damages. At trial, the court instructed the jury that the National League and American League were engaged in interstate commerce and subject to the Sherman Act. The jury found for Baltimore, and the National League and American League appealed to the D.C. Court of Appeals, which reversed, concluding that the business of hosting baseball games didn't involve interstate commerce and wasn't subject to the Sherman Act. Baltimore appealed to the United States Supreme Court.